During his short comments last night after the president introduced him, Brett Kavanaugh underscored this point. Cut 10, go.
My judicial philosophy is straightforward. A judge must be independent and must interpret the law, not make the law. A judge must interpret statutes as written, and a judge must interpret the Constitution as written, informed by history and tradition and precedent.
Let's go to September 23, 2011. We are assured by writers at National Review, by faceless, nameless editorial writers at the Wall Street Journal, by former clerks, by certain professors, by TV hosts and radio hosts, that Mr. Kavanaugh is a proven textualist and an originalist. How they know, I don't know. They tell us they read the opinions. Some of his opinions are spot on and some aren't. Most of his opinions are irrelevant, quite frankly. They just deal with the nitty-gritty of the kinds of cases that come up in the D.C. Circuit Court of Appeals. But I would think Obamacare is a crucial decision, wouldn't you? And he had an Obamacare decision, a case. Susan Seven-Sky, also known as Susan Savinsky, versus Eric Holder. Now remember what I told you. The lawyer in the case is Edward White. And obviously I'm only reading those parts relevant to Mr. Kavanaugh. Mr. White says, I will turn to the tax argument, and Congress can use its tax power. He says, Mr. White, this is the oral argument. So, for example, Congress have decided politically that, they'd raise everyone's taxes a certain amount of money, and if you bought insurance, you got a tax credit. They do that all the time, White said. If you buy an electric car, Kavanaugh interrupts. He says, well, let me just think about this statute. Suppose, just for the sake of a question, that it's $1,500, just for simplicity. You would say a statute that says pay $1,500 to the IRS if you don't have health insurance is perfectly constitutional. Perfectly constitutional under the tax power. But if it says pay $1,500 or you shall maintain health insurance and pay $1,500 to the IRS or purchase health insurance, if you don't want to pay the $1,500, that's unconstitutional. What's different about those two things? So he's saying, in other words, let's say the government says you're to pay $1,500 to buy health insurance, and if you don't, we'll penalize you. Or you pay us, the government, $1,500 for health insurance. Saying, what's the difference? In other words, the judge says, in the second one, you have an option. Pay to the IRS or buy health insurance. In the first one, it's just pay to the IRS, and they're going to provide a government-provided medical benefit. Lawyer White says, well, I think because it's under the taxing power and it's between you and the government, you're paying taxes just like you would on many things, and some people object to that, but you still pay it. That's a different premise than establishing the principle that Congress can require you as an American citizen, and where you're just at home, you're not involved in commerce, that you must buy a product from a private company for the rest of your life, whether you need it or not, because, well, Kavanaugh says, well, let's talk about a separate hypothetical. You say this statute, Obamacare, which in effect says you shall have health care. If not, pay a penalty. Again, we'll say $1,500. You say that's unconstitutional. A statute that says simply in the IRS code, if you don't have health care, you pay an assessment of $1,500. In your theory, says the judge, the latter's perfectly constitutional and the former's not. And they seem extremely similar in terms of their actual effects on citizen behavior. Why should we have so much turn on such a minute difference in phrasing? Lawyer White, I don't think it's minute just because of which enumerated power we're talking about. Kavanaugh, we're talking about the tax power. Okay, says Kavanaugh, so the tax power. If you don't have health insurance, you pay $1,500 to the IRS. Just like if you contribute to charity, you get a break. If you have a mortgage interest, you get a break. If you don't have health insurance, you pay a $1,500 assessment. That was what the House bill was. Everyone agrees that's perfectly constitutional. Of course, I don't. Perfectly constitutional. You say it doesn't pass muster under the tax power if it says you shall maintain health insurance, and if you don't have it, you shall pay a penalty of $1,500. You know it's very close, says the judge. He goes on. As the amicus brief, or friend of the court brief, I think some of the professors pointed out that this is very close. Lawyer White, it may be close, but again, you're talking about a relationship between you and the government versus a relationship citizen to citizen. And if I'm paying my taxes to the government and if somehow it's going to result in health insurance, that's a different situation than putting me into the commerce market to buy a product from a private company. I think that's a critical decision because you look at how Congress has always used the taxing power. Judge Kavanaugh, do you think the average citizen would feel more coerced to buy health insurance by the first rather than the second example? The first, again, was you shall have health insurance. If you don't, you pay a penalty of $1,500. The second was, if you don't have health insurance, you pay an assessment of $1,500. So one citizen looks at the first and says, I have to get health insurance. And by the way, his examples there are convoluted. He means to say something else. And so White says, I really don't understand your point. Kavanaugh says the coercion comes from money. Kavanaugh says, you raise $3,000 more. He says, on the second example, it's just a tax code provision that says if you have health insurance, that is, correction, if you don't have health insurance, this is him, not me, you pay an assessment of $1,500 on line 6 of your tax return, right? That is 100% constitutional. That was the House bill. The only difference in the final bill, and it's slight, but maybe it makes a difference, maybe it's more coercive, is you shall have health insurance. If you do not, you shall pay a penalty of $1,500. And my question is there really a difference in the coercive power of the government over the individual between those two examples? Lawyer White, I think there is. And again, it may be a subtle difference, but I think it's significant in that regard, is that when Congress is using its taxing power in this regard, there is, again, the political accountability. People don't like taxes, so politicians are more attuned to how they're going to pass a law, and there is a backlash in that regard for taxes. When you're dealing with the Commerce Clause, because the Commerce Clause has been expanded from its original thinking, it's if Congress has now used its Commerce Clause to force people to buy products, then that power is more unlimited, because all Congress has to do is set up factual findings. So even in the most decision from the Middle District of Pennsylvania, the judge notes there, he asked the government attorney if Congress accepted the principle, an apple a day, keeps the doctor away, and had findings for that. Can Congress require you then to buy an apple every day? And the answer there was no refusal of that. In other words, Congress can, if you follow the liberals. Judge Kavanaugh, well, what do you mean by that? We're on the tax clause now, and the require word is the key word. And the question is, if it's required by a $1,500 payment to the IRS, is that different from saying if you don't have an apple a day, you pay a tax of $1,500? Now we're getting to the nitty-gritty. Just stick with me, because it goes on. You don't have to call it a tax. Here we go, says Kavanaugh. The license tax cases make clear there is a paid fee for a license. And the Supreme Court upheld it under the taxing power, even though the court assumed that Congress did not have the power to regulate that under the Commerce Clause. And even though it wasn't called a tax. So the label, what I'm trying to do is tease out what the factors really matter. And it seems to me the mandate, that's the individual mandate, which says, of course, I'm me speaking now, if you don't get health insurance, you pay this penalty, which now they call a tax. It seems to me the mandate versus encouragement is one line you draw that has some force, I admit. And then another line you've drawn is the label. I'm trying to tease out whether the label really matters. Suppose, for example, that this law enacted had a penalty of $50 if you didn't have health insurance, called a penalty of $50. And then the next law called it a tax, and it was $2,000. Under your theory, the $50 is unconstitutional because it's called a penalty. The $2,000 is perfectly constitutional because it's called a tax. And I'm trying to figure out what sense that makes in terms of the label. Lawyer White, with regard to these hypothetical statutes you're talking about, whether they can do it under the tax power, we have to go back to what they actually did. He's saying, look, that's not what they did. They called this a penalty, not a tax. Now, why is Kavanaugh so focused on tax and not penalty? For the same reason John Roberts called it a tax and rejected penalty. Because in constitutional construction of the argument, if they call it a tax, I disagree with this, by the way, but this is their position. If they call it a tax, Congress can do it, okay? But they do not call it a tax, which is why the dissent in the Obamacare case in the Supreme Court was so furious, talking about rewriting the statute. What is Mr. Kavanaugh doing here, Mr. Textualist? Well, they don't use the word tax, but that's just a label, right? Judge Kavanaugh, they did not disclaim the tax clause power. So now he's saying, well, they didn't actually disclaim that it's a tax, and they never said we're proceeding only under the Commerce Clause power. That's been repeated often, but it's not quite accurate. You know, that's not true either. Obama even gave an interview, and I believe it's named after him, the law, and he signed it, and his administration actually helped write it with Congress. They went on and on and on. It's not a tax. Lawyer White, when you look at the findings, Congress is only talking about its regulation under commerce, its ability to regulate commerce. Congress, when you look at the labels Congress used here, it's not just the labels of saying this is a tax, this is a penalty. It's what Congress did beyond that. Congress in this statute, but, says Kavanaugh, it's in the tax code. It's paid on your IRS form. It's assessed and collected in the same manner of subchapter B of Chapter 68. Which is the Internal Revenue Code. It's a big tax-related provision. Now, you still may have a good argument on the fact that it's a mandate versus encouragement. I think that's a fair point. Lawyer White, when you look at the statute, you have to look at the entire statute. If everyone complies with the mandate and buys health insurance, the government doesn't receive a penny because all your money is going to a private insurance company. When you look at what Congress did in the statute, Congress was very particular. Congress not only called it a penalty, Congress in other areas of the statute designated things taxes. So you had the 10% tax on tanning. You had the medical device tax. Congress also listed in the health care law 17 tax-generating provisions. It did not list the individual mandate in them. That is, it's a tax clause. Judge Kavanaugh. So something labeled a penalty, says Judge Kavanaugh, can never be justified under the taxing power? I don't think the label is not dispositive, but we're not just saying that. Right. That's what I'm getting at. Judge Kavanaugh, I'm trying to distinguish a non-punitive civil penalty, mouthful, from a tax that's justified under the taxing power. How do I tell the difference between those two things? Lawyer White, you have to look at the structure of the statute. You have to look at the language Congress uses. In this case, Judge intervenes, well, you just said the language is not dispositive, so how? Okay, says the lawyer, you have to look at the purpose. Is it a tax revenue statute? This statute, when you look at it, Judge interrupts, well, the Supreme Court's long said, as long as it's revenue raising, we don't get into that issue anymore. Whether it's the Sanchez case or Sunzinski or Bob Jones, there are a lot of cases. Lawyer White, right. But the Supreme Court also says that there is a difference between a tax and a penalty. And a tax is to raise revenue, and a penalty is to compel behavior. The penalty here, if you find the individual mandate, is to compel. Were you able to follow most of that, Mr. Producer? Mr. Kavanaugh, the textualist, the man who understands separation of powers, was rewriting the statute. And you know what he did in the end, Mr. Producer? He argued that his major concern was the Anti-Injunction Act, which prevents the court from hearing it until 2015. What that means is the case isn't ripe because the tax or the penalty has yet to be applied to anybody. And so you need to come back once that happens and then make your argument all over again. In other words, in the end, he ducked. He made a technical decision. But throughout this oral argument, it wasn't the leftists on the court, the old Carter appointee, Harry Edwards. It was the Bush appointee, Kavanaugh, going on and on and on that it's a tax. What's the big deal between a tax and a penalty? The big deal is it made all the difference in the world. You have to assume that Kavanaugh would have voted with Roberts on this because they both came at it from exactly the same position. He is not Scalia. He is not Thomas. He is not Alito. And in this case, he wasn't even Kennedy. So we'll see. The conservatives on the Judiciary Committee politely and legitimately need to pursue this. This is a big deal. Goes to this issue of textualism and originalism. Now, my purpose here isn't to sabotage, isn't to upset, isn't to anything. But why would we be ostriches here and put our head in the sand? There are legitimate questions that need to be asked from a constitutional perspective of Kavanaugh. There's a reason why the rhinos, almost to a person, back this gentleman. So do some conservatives. So do many never-Trumpers. So that by itself is not definitive.